All right. Good morning, everyone. And thank you, Alyssa, for introducing me. And welcome, everyone, to today's SAVAT session on SARTs, also known as Sexual Assault Response Teams. My name is Summer Gaines Wheeler. I am MCASA's Sexual Assault Forensic Exam and Sexual Assault Response Team Policy Advocate. And as Alyssa already stated, for today's training, you all will be hearing from three speakers, including myself, regarding a few of the roles that are involved in a SART, including forensic nurse examiners, law enforcement, and prosecutors, and more so how they tie into the work that you guys all do as advocates. Now, I will be presenting on the role of the forensic nurse examiner, also known as the FNE. If you guys do have any questions that come about this portion of the presentation, please feel free to drop them in the chat and Alyssa will alert me, given that I can't view the Zoom screen in the chat due to me presenting. And then if you guys have any other further questions, please email me after the training. And with that, we'll go ahead and get things started. So obviously, you guys are going to be learning about a few different roles within the SART and how that applies to the work that you guys all do as advocates. And so these are just some of the main objectives that encompass the various takeaways for each presentation and assigned role. So by the end of this SAVAT session, you all as advocates should be able to, one, compare and contrast your role with the role of law enforcement, forensic nurse examiners, and prosecutors. Two, describe what a sexual assault forensic exam is. Three, explain the importance of advocacy throughout the criminal justice process. Four, identify the three responsibilities of law enforcement officers. And five, understand the relationship between prosecutors and victims to better manage victim expectations throughout the criminal justice process. So I know that you guys are going to be digesting a lot of material today. I don't think my presentation should take too much of your time, but I still really appreciate and value your guys' input, participation, and engagement. And so I do have one activity that I would love for you all to participate if able and willing. If you guys are able to type in the chat whether you have ever experienced and accompanied a survivor during a sexual assault forensic exam as a victim advocate, that would be great. And then Alyssa, if you can share folks' response, I would really appreciate that. We're just trying to gauge the audience today.
All right, Summer, this is Alyssa speaking. We have some mixed responses here, a lot of no's, and a couple of yeses.
Okay. Well, I'm sure that's going to remain the same, so I'll leave it at that. But it's great to see that there is a variety, whether you have attended a safe and accompanied a survivor before, or this is going to be your first time learning about it. I really hope that this training will, give you guys a better understanding, regardless or not, of your experience before. So now we're going to go ahead and really get things started. And I think the first thing that we really need to do is actually describe what a SAFE is, right? So what does it stand for? A SAFE is a sexual assault forensic exam, and it is a procedure that provides survivors with important medical care and allows for the collection and preservation of potential evidence after an assault. And so a helpful way to understand a SAFE is to break it down into two parts. You have medical attention, and then you have evidence collection. The medical attention portion includes elements such as checking and treating for potential injuries, providing STI prevention, treatment, and or testing, as well as providing pregnancy prevention. So, for example, offering emergency contraception pills like Plan B. That is the medical attention, right? So then you have the evidence collection portion, and that includes taking photos of the injuries, collecting DNA, and collecting any clothing items. And as stated on this slide, forensic nurse examiners, also known as FNEs, are the professionals responsible for conducting the exam. Now, I do also want to note that in the state of Maryland, sexual assault forensic exams conducted up to 15 days after an assault occurred will be reimbursed, meaning the survivor is not responsible for paying for the services that they received. Now, the new law also does not specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. And I'll kind of touch upon this towards the end of the presentation as well. So, when understanding the process of receiving a sexual assault forensic exam and reporting the sexual assault, there are a few different options available to survivors. So, a survivor can report a sexual assault either to the emergency department, law enforcement slash the like police precinct, and or to a rape crisis center advocate. Now, it is possible that survivors reporting to the ER or emergency department, they may choose not to receive the sexual assault forensic exam and may simply be interested in receiving the medical care, that medical treatment, right? That is okay and that is allowed. If they choose not to receive a sexual assault forensic exam for whatever reason, advocate presence should still be offered to them. Additionally, Child Protective Services and Adult Protective Services, also known as CPS and APS, are called in cases that involve child sexual abuse or cases that involve vulnerable adults. And according to Maryland's Office of the Attorney General, vulnerable adults are people over the age of 18 years old who lack the physical or mental capacity to provide for their daily needs. So, advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including the exam room. Before an exam, advocates can work to address any acute concerns identified by the survivor, as well as work through any questions about the exam process. Advocates can also explain their role as advocates, but also the role of the forensic nurse examiner and the expected services that come along with a SAFE. And lastly, they can review any potential reporting options if the survivor is interested in taking that route. During the exam, advocates can help support the survivor through any or all parts of it if they are invited and welcome to do so. So when they're invited, they can include offering, any sort of grounding strategies, co-regulating, offering words of encouragement, and empowering the survivor to choose from the available options that come with the exam. Now, I do want to note that it's important to be aware of what to do if you are invited into the exam room. For example, you should not be speaking for the survivor or telling them what they should or shouldn't do. And you shouldn't be touching the nurse's tools, right? So overall, it's just very important to understand your physical place and space within the room itself. Additionally, it's important to be prepared to ask the survivor if they would like privacy or for you to stay during various parts of the exam. So that's kind of why I was saying before, they are available during any slash all parts of the exam, but it's important that the survivor is requesting that. So for example, some survivors may want your physical presence during the narrative portion of the exam. So when they're, verbally describing their assault, what happened, and any other sort of verbal notes that are made known. But they may request privacy during a speculum exam and or during evidence collection, right? So when there's actually some sort of physicality to the SAFE. And so it's just very important to be mindful of bodily autonomy and respecting survivors, comfort and meeting them where they're at. After the exam, Advocates can work on a safety plan for the post-crisis intervention period, as well as connect survivors with ongoing advocacy and community referrals, as well as address any other ongoing concerns that the survivor may have. The safe hospital, meaning a hospital with a safe program, should have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. And so advocates can then work with the forensic nurse examiners and potentially law enforcement to ensure a timely survivor-centered coordinated response to the hospital. And I want to reiterate once again, a survivor may choose to have an advocate at the hospital, even if they choose not to have the sexual assault forensic exam completed. And likewise, what we just talked about now, survivors are not required to have an advocate present and may choose not to. And so in that situation, you guys as advocates can still provide any contact information or other relevant community referrals for the survivor to reach out to if they want in the future. All right, so now I want to talk about what actually takes place during the sexual assault forensic exam. So the SAFE includes several important elements like a detailed interview by the forensic nurse examiner, a bodily exam, evidence collection, photographs, and documentation of findings. Now, it's important to note that a survivor may choose not to receive any portion of the exam at any time. That is perfectly okay. We want to respect their bodily autonomy and what they're comfortable with. During the interview, survivors can disclose what they choose about the assault. However, an advocate can gently encourage details as it will impact medical prescriptions and evidence collection. So, kind of using the training that you guys are developing as victim advocates and using your discretion to, better support this process by being gentle, encouraging, but also not crossing that fine line either of making them do anything that they don't want to do. And then lastly, what we can see is that the exam can last anywhere between 3 to 6 hours. That is a long time. And so it's very important that, we are doing check-ins with the survivor, asking them if they're okay, applauding them for what they've done so far, and just really supporting them through expressive compassion. Now, during the external part of the exam, the forensic nurse examiner will look for any bruising, wounds, or injuries that may have occurred during the assault. If any injuries are present, the forensic nurse examiner will use photos to document the wounded areas, and you can kind of see some examples of this on the screen towards the right. There are also cases where injuries are not visible. So, for example, we see this a lot in strangulation cases. So, in these instances, what is called an alternate light source, also known as ALS, may be used to photograph the areas. An alternate light source is a technique that can detect bruising or injury that has occurred beneath the skin layer and that's not available to the naked eye. And so you can see an example of this at the bottom of the screen of the woman holding that tool. So another part of the exam that takes place is swabbing. So a forensic nurse will use cotton swabs to collect evidence from various parts of the body, including the skin, the mouth, and underneath the fingernails. Additionally, a genital and an anal exam are also completed in which a forensic nurse conducts both internal and external swabs of the area. Now, the areas that are swabbed are based on the victim's narrative of the assault provided to the forensic nurse examiner. And so this is why, as I mentioned before, providing details may be especially important as it can guide evidence collection and increase the likelihood of obtaining DNA. However, as advocates, one should never speak for the survivor or force them to provide more details than they are willing. However, during the process, supporting them and helping explain why these steps are important in terms of providing those details may be beneficial. All right, so we kind of touch upon the medical part and the evidence collection part. Now, there's also something known as evidence preservation. And there are several things that a survivor can do to best preserve evidence before getting a SAFE completed. For example, we recommend a survivor not changing clothes because the survivor's clothes will be collected into evidence during the sexual assault forensic exam. Now, if the survivor does change clothes, that's totally fine. We just ask that they bring the clothes with them to the hospital so that evidence can still be preserved as best as possible. Additionally, it's advised to refrain from using the bathroom, eating, drinking, or brushing teeth. And we also advise to refrain from showering or taking a bath beforehand to best preserve evidence. I do want to emphasize, though, that if a survivor has done any or all of the previous listed activities, please do not discourage them from getting a sexual assault forensic exam completed. The forensic nurse examiner will still attempt to collect as much evidence as possible. So the last thing that I kind of want to touch on is what occurs after the exam. So as I mentioned before, SAFEs are free of cost with or without insurance as they are government funded. And as mentioned before as well, SAFEs and medical care are free up to 15 days after the assault occurred. Now, I do want to preface that after the 15 days, it is not guaranteed that the state will cover these services as they are not obligated to reimburse those costs. Some jurisdictions may use other funds to try and get it covered if they conducted the exam after those 15 days, but there's no guarantee. Additionally, I want to note that survivors have the right to a forensic exam, and they do not have to report to law enforcement in order to receive the SAFE. But after those 15 days, the forensic nurse examiner does have discretion on whether if an exam is conducted or not. However, as an advocacy agency, we generally discourage anyone from denying survivors a sexual assault forensic exam. Additionally, the forensic nurse examiner or advocate will inform the survivor about community resources available to them, including counseling or support groups. And as mentioned before, the survivor will also be offered emergency contraceptives, STI prophylaxis, and HIV prophylaxis free of cost. And I also want to mention that there has been discussion about medical attention only coverage. According to SARU, also known as the Sexual Assault Reimbursement Unit, medical only exams are covered, as well as that portion, whether evidence was collected or not. All right. And so the last thing that I want to do to wrap up this portion of the presentation is to show a video that really highlights the value of advocacy during a sexual assault forensic exam. Now, I do want to provide a content warning. We are listening to survivors who are giving their direct and personal experiences. So I do want to put a trigger warning for that. But I do hope that you guys are able to still feel comfortable watching this, as it really highlights the important work that you guys all do and will continue to do for survivors. Volume.
Rape is a reality across the globe, including right here in Chicago. For For survivors, support is crucial on their road to recovery.
I'm an 11-month survivor of rape.
According to the CDC, 1 out of 5 Illinois residents have reported a rape. One local organization seeks to help victims of sexual abuse by providing immediate, round-the-clock support in 14 area hospitals.
Essentially, if a victim of sexual violence shows up at any of those hospitals, the hospital pages us, we dispatch an advocate, it doesn't matter what time it is, and that advocate is there really solely for the victim.
During a traumatic time like this, you are not able to think or understand what people are saying. So it helps to have someone there to be supportive, to actually advocate for you and help you navigate through the system, and to provide you with all of the services that you're entitled to based on the law and based on what your needs are.
The survivor we spoke with was raped while on a date, and unfortunately, she is not alone. 2 out of 3 reported rapes are committed by someone the survivor knows. Sharmili says it's crucial to let survivors know you support and believe them early on in the process.
When I was in the emergency room, I was asked if I wanted an advocate, and I said yes. So my advocate, Providenza, showed up within an hour. It was just so reassuring to have somebody who believed me and was on my side.
There's actually been research done that shows that having immediate care right after someone is assaulted and in an emergency room setting actually improves the ability of the person on their road to recovery in terms of their emotional healing, but also in terms of their case being taken as seriously as possible.
If I had not had an advocate, I would not have been aware of the civil no contact order that I was able to get temporarily. I would not have known about Illinois law that funds the ER visit and the follow-up care. I wouldn't have pursued probably therapy on my own to help heal, and that was such an important piece of healing.
When it comes to making societal changes, seemingly small steps can make a big impact.
Most likely, there are people in your life who are survivors of sexual violence that you don't even know about. There are people that you hang out with, there are people that you go to school with, there are people that you work with. Part of what we're hoping is that people will talk a little bit more about the issue of sexual violence, because all of us are bystanders in some way. And so we have the ability to interrupt behavior, language that supports sexual violence. Rape jokes.
One that is clear and simple.
No is no. Anything other than yes, let's do this is no. No matter what age or how I'm dressed or what time of night it is or how much I had to drink. I am a human and I deserve to be treated with respect.
Sexual assault is a traumatic event, but there is hope.
I am so much stronger than I think I am because I survived this. And not only did I survive, I'm thriving. I grew through this process. It was painful and it hurt so bad. And there were some really low lows, but I survived. If one person who sees this segment can benefit and seek the help that they need to heal from this, then my assault won't be in vain.
If you or someone you know is a victim of sexual assault, please contact the 24-hour Chicago Rape Crisis Hotline at 888-293-2080. For more information, head to our website, livinghealthytv.com.
All right, so hopefully that video gave you guys a little bit more insight about the importance of the work that you all do. And that does conclude my portion of the presentation. Now, if you guys have any questions regarding this, feel free to email me. I'm more than happy to support you guys in that step. And I'm going to now hand things off to Cameron, who will present on the role of law enforcement agencies. And I wish you all the best with the work that you all do. Thank you so much.
Hi, everyone. Give me a second to share my screen. Um, okay. Alyssa, can you all see my screen?
Yep, looks good.
Okay, awesome. Hi everyone, I am Cameron and I am the SART Policy Advocate with MCASA. Today I'm going to be talking to you all about the role of law enforcement and how they collaborate with you all as victim advocates to serve and support survivors. Full disclosure, I've never worked for a law enforcement agency, so I do not claim to have this lived experience. This is more so just a high-level overview of how law enforcement engages with survivors and you all as victim law enforcement can receive these reports. The first is through hospital personnel. So this occurs when a survivor reports directly to a hospital for a safe before they've contacted law enforcement. So when they arrive at the hospital, they are given the option to inform law enforcement and report the assault, but they are not obligated to. And this does not impact their right to a safe. If a survivor would like to involve law enforcement, they can let the hospital personnel know, and the hospital personnel will be the ones to contact law enforcement and have them respond to the hospital, and then law enforcement will eventually interview the victim. Survivors also have the option to contact law enforcement themselves directly, and there are three ways they can do this. They may report it directly after an assault occurs. They might do it while an assault is in progress, or they also have the option of a delayed report. A delayed report involves waiting to contact law enforcement, and this delay of time can be anything from days to weeks, to even years after an assault. Regardless of when it is, law enforcement will still take that report and investigate. Law enforcement can also receive reports from a third party or a witness, but as a reminder, law enforcement is frequently limited in what they can do with third party reporting, except under certain circumstances like children or vulnerable adults. Simply having a witness contact law enforcement cannot force a survivor to engage with the criminal justice system. In most cases, a patrol officer is going to be the first responder to meet with a victim before a detective is called in. Next, I'm going to go over the responsibilities of law enforcement, and I'm going to talk about the response. The initial interaction between law enforcement and survivors typically involves identifying the survivor's needs and laying the groundwork for future interactions with survivors. This initial interaction is really crucial because it's the opportunity law enforcement has to build rapport and trust with the survivor, and let the survivor determine how they would like to move forward. During these interactions, it's really important that law enforcement remembers to speak with compassion. If you joined our neurobiology of trauma session last week, we discussed the FETI technique, which is the forensic experiential trauma interviewing technique. It focuses on compassionate interviewing, building rapport, and being empathetic. So, to encourage participation in the criminal justice system, technique for law enforcement officers to use. It's also really important to note that if a survivor reports to law enforcement before they have received medical care, law enforcement's number one task at that point is to assess the need for emergency medical care and inform survivors of the SAFE process and how it can then aid in a criminal investigation. Any survivor that is interested in receiving a SAFE should absolutely have the opportunity to do so, and that includes survivors that have a delayed report. Survivors, even if evidence may not be collected, and law enforcement is not allowed to deny a survivor access to a safe. As an advocate, that's where you can come in and ensure that forensic medical care is accessible. And it's also important to advocate that safes are available for 15 days post-assault. Again, like as Summer mentioned, the earlier the better, but they do have up to 15 days. So after law enforcement has addressed safety needs and medical information to identify and locate the suspect. Not only is this helpful for the investigation, but it is also crucial for the survivor's safety and in some cases, even the support group, like family members' safety. Law enforcement typically initially seeks the basic information on where an assault occurred. From here, they are then able to secure the scene and begin examining the area for any additional evidence. It's also important to note that law enforcement may ask a survivor if they told anyone about what happened. So if they told a friend or a family member about the assault, and this is especially true for delayed reporting. It's a very difficult question, but the information is important as it can corroborate the survivor's story. And advocates can support survivors by explaining that it's not that law enforcement is doubting their report or doesn't believe them. They're just looking for supporting evidence, which can be essential in an investigation. From here, law enforcement will then do what we all know them to do, which is determine whether or not to make an arrest. So in the preliminary investigation, they're deciding whether or not an immediate arrest of a suspect is something that they need to do. And it's based off of factors like probable cause and whether or not an immediate arrest is necessary to protect the community from further threat. So law enforcement responsibilities initially lie in 3 areas: protecting and supporting the victim, gathering preliminary information, and then protecting the crime scene to collect evidence related to the case. It's important that when law enforcement is doing this work, they are being trauma informed, and part of that includes involving you all as victim advocates. Most law enforcement agencies work with their local rape crisis centers because they can provide support beyond just the initial investigation. Law enforcement and advocates can work together to complete other tasks like safety planning, childcare, housing. Some offer job assistance. So it's important that law enforcement uses the local rape crisis center to connect survivors to that type of immediate and ongoing support. Again, bringing it back to the neurobiology of trauma training from last week, law enforcement should be aware that survivors may experience symptoms of trauma that affect their ability to recall information, especially in chronological order. And survivors may experience a range of emotions that can be anywhere from depression or flat affect to hyperactivity. It's important that all parties recognize that there's no correct emotion for a survivor to display. These are all normal responses. And all investigators should be trained on trauma-informed interviewing techniques and understand the neurobiology of trauma so they are able to support the victim and conduct a successful interview. So next, I'm going to talk more about the aspects of the investigation. So law enforcement is responsible for conducting a thorough criminal investigation. However, the most important step is that they need to ensure the safety of the survivor and their support group. Addressing safety can ensure that a survivor feels comfortable enough to participate in the criminal justice system. And as an advocate, safety is also something that you should be sure to evaluate and address throughout the criminal justice process. Once survivor safety is addressed, investigators should determine if the victim knew the suspect or had any previous contact. It's really important that we remember that despite the belief that rapes are perpetrated by strangers, statistics show that approximately 75% of rapes are committed by someone that is known to the individual. Knowing if the offender is known or a stranger is really essential in determining the next steps of an investigation. Stranger rape cases may require the survivor to participate in a more detailed interview immediately, as there could be a threat to the community. But when the offender is known, law enforcement may be able to obtain basic information that will allow an investigation to begin while also giving the victim the space they need to rest and recover before they participate in the entire interview process. Some items that may be important for law enforcement to obtain immediately include if the victim knows where the suspect is, how they left the scene, when they left the scene, do you know where they're going? And also including details of additional information such as the use of a weapon or force. or threats or involvement in drugs is also essential to criminal investigations and the prosecution of cases, because these details can give law enforcement the ability to determine whether they need search or and seizure warrants. Another part of the investigation is the forensic analysis of the sexual assault evidence kit, which my colleague Summer just talked about. This includes looking at the photographs, testing DNA samples, and more to help with an investigation. So as a victim advocate, you may be present for some of these questions. And your job, one of the things you can do here is some of the questions may come across as sounding a little victim blamey, like asking what someone was wearing or if they had had anything to drink. So it's important that as the advocate, you are able to translate that for survivors and provide background and context to help avoid re-traumatization and develop some understanding on the part of the survivor, because these questions are often just important to the investigation, and unfortunately just do come across as victim blaming. So next I'm going to talk to you all about the different types of evidence that law enforcement can collect. There are multiple types of evidence that they may be looking for or including in their investigation. And the first one is the sexual assault evidence kit, or SAKE, which again, Summer just went into a lot of detail about those and the whole forensic exam process. Survivors have the right to a free sexual assault forensic exam up to 15 days after an assault. And at this exam is where the SAKE is collected. And then law enforcement is responsible for storing the SAKE along with other evidence from the crime scene, and all other elements of physical evidence. Law enforcement is required to hold a sexual assault evidence kit for 75 years. Some of the evidence, such as clothing that the survivor is still wearing or bodily fluids collected during the exam, are collected by the forensic nurse examiner. After collection for inclusion in the kit, it is then law enforcement's responsibility to obtain the kit from the SAFE program and transport it to storage at the law enforcement agency as evidence. It is then law enforcement's responsibility to safeguard the items of evidentiary value in accordance with Maryland law and best practices. Other forms of evidence that we're seeing a lot more of today include cell phone communication and communication on social media. This could be Snapchat, Instagram, Facebook, Twitter, all of those. And of course, this is not an exhaustive list of possible evidence materials they may collect. Depending on what the survivor tells the law enforcement, that can guide their collection of evidence. So if a survivor comes forward and says, yes, they were at a party and they were drinking, law enforcement can use that to then go to the scene and obtain cups from the party and use those as evidence. Next, I'm going to talk to you all about the option of anonymous reporting. So survivors do not have to report to law enforcement. They have the right to an anonymous exam. And this means that there will be no official police report until the survivor chooses to initiate one. An anonymous kit will be stored with law enforcement, but there will be no personally identifiable information on the kit. And that kit is also, law enforcement is also responsible to hold anonymous kits for 75 years. In those 75 years, a survivor can come forward at any point and initiate an investigation. It's at this time that law enforcement would open the kit and gather information and details of the assault. And then once that happens, there will be information on the kit, but until that point, there is no personally identifiable information. The anonymous report option, or some people call it the Jane or John Doe option, allows victims to preserve this evidence and receive medical care without speaking to law enforcement. It gives survivors time to process and recover from the assault prior to reporting. And then if/when they are comfortable, they are then able to move forward with the criminal justice process at their own discretion. As an advocate, be sure to discuss how anonymous reporting may affect the criminal investigation. It's important not to make survivors feel that they have to report the assault immediately. but you may want to inform survivors that evidence collection from the scene or even from the offender may be lost if they choose to not report immediately. But remember also, this is the survivor's decision, so ultimately it is up to them. Try not to incorporate your personal opinion and let them know that it is okay to not report immediately. Encourage them to just do what is best for them and let them know that you want them to make an informed decision. So now I'm going to ask you all, just before I get more into your role as an advocate during an investigation, if you could just put it in the chat. How do you all think that advocates can support survivors while working alongside law enforcement? Okay, I'm seeing presence, asking for breaks for clients, ensuring trauma-informed care, offering resources and being the middleman, explaining the process, and making sure law enforcement is trauma-informed, standing up for the victim, meet the survivor where they are at in regards to emotional and physical support. Awesome. Thank you all so much for participating. Those are all very good answers. So now I'm going to go into your role as an advocate during an investigation. The role of an advocate during an investigation, as you all know and put in the chat, is that it is all about the survivor. If you are involved in the interviewing process, you want to ask what their needs are and inform them of their rights, like the right to a safe, to a kit, or a crime victim's rights attorney, and making relevant referrals. You can also provide support and accompaniment to victims during an exam or an interview and check in with their emotional state and provide reassurance and validation. If they need to take a break, you are also there to help advocate for that. But you also want to be mindful that when you are asking if the survivor would like a break, be mindful of if it's a snack or drink or bathroom break, because a survivor should not eat or drink anything if they are still waiting for a safe. Additionally, survivors should try to refrain from using the bathroom before an exam. But if they do need to use the restroom as an advocate, that's something you can inform the nurse of so that a urine sample can be collected. As an advocate, if you aren't sure about something, you are always able to ask the FNE or nurse available. Advocating for bathroom breaks, snacks, and drinks is much different during an interview, or if an exam has already been completed. Also remember that silence is okay. Your presence alone, I remember someone said in the chat, just presence. Your presence alone may be the only support that a victim needs while they process the trauma they experienced. Advocates can also assist victims in asserting their rights. So while we encourage victims to come forward, we need to remember that under the Violence Against Women Act, no victim is required to speak with law enforcement or participate in the criminal justice system. So as an advocate, you can remind them of this. It is also important that you do this throughout the investigation. So for SAKI testing results, untested kit reviews, for a SART, things like that. And then also, as an advocate, your role can also just be a source of comfort. During the law enforcement interview, it is appropriate to remind victims that they can take a break or that they can ask questions. And keep in mind that although it is best practice for law enforcement to allow an advocate to be present during victim interviews, your local jurisdiction may not permit it. And if that's the case, you can still provide information on best practices and agree to not interrupt the survivor or guide their story and response. If they still do not permit you after that, you can remain outside the interview room and be available to provide support after the interview or when needed. Some advocate basics, role of the advocate. You want to advocate for the survivor's desires and provide emotional support, assist in safety planning, and help with other referrals. Remember that it's not always going to be about the investigation. you as advocates are going to be a lot better at the healing and support process for a survivor than the investigative process is. So really making sure you're there. A 2006 study found that survivors who had the assistance of an advocate were significantly more likely to have police reports taken and were less likely to be treated negatively by police officers. And they also reported less distress after contact with the legal system. So, your presence during that criminal justice process is really crucial because it can make all the difference in their experience. And while advocates certainly strive to protect relationships with other professionals, their role requires them to work on behalf of each victim's stated wishes, not law enforcement. So now I want to go over some things to avoid as an advocate, which can often be difficult, but it's important that we attempt to do these things. As an individual, you may have strong feelings about whether or not a victim reports, but it's really essential that you keep any of your own opinions out of conversations because you can directly impact a victim's decision. Survivors may ask for advice, and if they know somehow that you are a survivor, they may ask what you did in their shoes or what you would do. It's really important to not share personal decisions or self-disclose. Because it is about this survivor's needs, and there is no right or wrong or perfect way of doing this. If you find yourself in a situation where a victim asks what you would do or what you did do, it's important to know how to answer this question in a manner that highlights the victim's unique circumstances. So if you're asked by a survivor what you would do or what you had done, you can try saying something like, I think it's really important that we focus on your current circumstances. Every individual is different, and although it may seem like it will be helpful to hear what other people have or would do, you need to make sure you are making the best decision for you. So really just always making sure that the survivor is at the center of the conversation and making decisions for themselves is something you want to do, and you really just don't want to provide your personal opinion. You want to be honest with each survivor, so you want to avoid making promises. Promises can lead to a false hope, and if they do not pan out, if the suspect isn't arrested or convicted, the pain and disappointment from that can result in survivors refraining from engaging further in support services. It's much better to be empathetic and apologize and say, I'm sorry for what you're going through. I believe you. I believe this happened. Than it is to make a promise that justice will be served. Keep in mind that not all survivors have the same view of justice, and that view of justice can change over time. So allow each survivor to define what it means for them, even if that just means they want time to heal and recognize that they experienced something traumatic, and then support them in that journey. You don't want to make any promises. So in summary, it's important that you recognize that all survivors will respond to an assault the same. Not all survivors will respond to an assault the same. Their emotions and demeanor may vary, and this is not something they can control. It's an innate neurobiological response. Remember that not all survivors will want to report the assault to law enforcement. And because of this, you can provide information to each survivor to ensure that they make an informed decision, but again, do not provide your personal opinion. Focus on the survivor's needs, especially safety, especially in the beginning stages of the investigative process. Safety is of the utmost priority. Support the survivor during the investigative process. If you are permitted to sit in on interviews, be sure to advocate for the survivor's needs and prompt investigators to provide clarity if the survivor is struggling with a particular question. Really important is do not speak for the survivor, because not only is this taking away their autonomy, but it can affect the investigation and potential prosecution or conviction. It's also important that you know your own agency's services and other local resources so that you are able to make referrals when needed. And finally, know your confidentiality requirements. protect each survivor's personally identifiable information and their care plans. Even if a survivor is participating in the criminal justice system, remember what your requirements are for confidentiality. You want to keep their information private and secure, and law enforcement may want information that was provided to you, but unless you have the survivor's consent, you cannot provide that information. So you must maintain confidentiality as required by your discipline and funding avenues through the Violence Against Women's Act. That concludes my presentation on the law enforcement role and your role as an advocate with law enforcement. Thank you all so much for listening. I am going to stay on for the rest of the presentation, so if you have any questions, you can either put them in the chat or I guess ask them after Brandy's section, Alyssa.
Yep, that works. Thank you again, Cameron, for that presentation. And again, as a reminder, to go ahead and put questions into the chat. We'll do a Q&A after the role of the prosecutor presentation, which we're going to begin in a moment from now. And any unanswered questions today will be sent to the presenters for follow-up. And I will now turn it over to Brandy.
Hello, everyone. I'm Brandy McGee. I'm a staff attorney here at SALI, and I will be speaking today about the role of a prosecutor. A prosecutor is a special kind of attorney, and we'll go into exactly what makes them special. So first, we have a Zoom poll. Thank you, Alyssa. And we're asking, what are prosecutors called in Maryland? Now, it really depends on the state, so every state is different. But here in Maryland, we'll see if you guys know what we call them. Give everyone another minute. It looks like most of us do know that in Maryland, they're called state's attorneys or assistant state's attorneys. That is correct. You may have heard the term district attorney or DA in like a movie or a show. I think it's in Batman where they talk about the DA a lot. These all mean prosecutors. They're just called different things in different states. Next, we have another Zoom poll. Who do prosecutors represent in a criminal case? So we have a victim, a defendant, the victim and the state, or just the state. And the state means our state of Maryland. Give everyone another few seconds for that. And this one is really tricky, and that's why we're going over it. So it looks like we are a little bit torn about whether it's the state or the victim in the state. The technical answer is they only represent the state. Prosecutors do not represent victims, although they do work alongside victims because victims, especially in sexual assault cases, are usually the state's key witness. So while victims do have certain rights when it comes to what the prosecutor must share with them throughout a case, the prosecutors only owe a duty to the state. There's no attorney-client privilege between them and the victim, and that's why victims' attorneys, like SALI attorneys, are so important. We have one last poll here. Who decides if criminal charges are filed? This one is also kind of tricky because as you watch TV or movies, you may be misled by who actually files the charges. Okay, yes. It looks like most of us understand, or maybe got my hint from what I was saying, that the prosecutor is actually the one that files charges. In media and even in common parlance, people will also often say, I'm going to press charges against someone for harming me. However, that's not technically the case. Technically, the prosecutor is the one with the discretion to press charges. So as you can see, there's quite a few misconceptions about the role of the prosecutor, which is why we're having this presentation today. And just for fun, I got a couple of well-known prosecutors from media. So if you remember, if you've seen Legally Blonde, you remember that these three are the defense attorneys. And then this woman here is the prosecutor who is prosecuting their client for the crime of murder. And then in My Cousin Vinny, Joe Pesci is the defense attorney for his cousin. And this guy on the right is the prosecutor who's prosecuting them for the crime. So that just helps you kind of visualize who the prosecutor is and what their role was in those cases, if you remember those movies. As we said, prosecutors are attorneys who represent the state. Sometimes they represent the whole country in the case of like the Department of Justice. They do not represent an individual survivor, so there's no attorney-client privilege. That is why it's so important to have a victim's attorney that you can share information with and have privilege with. Prosecutors are subject to a wide array of ethical obligations, including discovery obligations. So if a victim shares some sort of evidence with the prosecutor then has to turn it over to the defense attorney. Whereas if a victim shares something with their own attorney, their own victim's attorney, we do not have to turn that over to anyone. In fact, we are not allowed to turn it over to anyone without their permission. So in Maryland, there is an official capital S state attorney in every county. That person's elected, and then the lawyers who work underneath them are called assistant state's attorneys. These are the ones that we usually encounter here at Sally. They work in the district and circuit courts to prosecute sexual violence cases. So they decide if someone gets charged, which crimes are charged, whether to pursue a plea agreement or an actual trial. The vast majority of the time, there is a plea agreement. That's something that a lot of clients don't know. They also are in charge of the entire trial strategy. So what evidence to put up, what expert witnesses, fact witnesses, and they also advocate for certain sentencing after a conviction secured. So the judge will consider what the prosecutors think the sentence should be. Of course, the defense attorney will also do the same. So an important thing to know about prosecutors is that they have very, very powerful discretion. They have the sole discretion to determine whether to prosecute a crime or not. And here we have cited an important Supreme Court case from the 70s, which outlines this discretion. Unfortunately, for a lot of clients who are disappointed if charges are not pressed, we have to explain that although they can get a meeting with the prosecutor to receive an explanation, it is within the prosecutor's sole discretion, and there's nothing you can do to appeal that decision or really change that decision above them. It stops with them. Prosecutors evaluate what kind of crime is taking place, what the evidence is. To charge someone, just to accuse someone formally of a crime, there must be probable cause, so there has to be some level of evidence. And then they have to consider if there's sufficient evidence to actually prove that case in court beyond a reasonable doubt. They also have to consider their objectives in charging. For instance, will the community at large be safer if this person is charged or sentenced? Their loyalty is to the entire community, not just the victim. Of course, the victim is part of that community, but their obligation really is to keep the community as safe as possible. Now, probable cause to press charges involves sufficient reason based upon known facts to believe a crime has been committed or that certain property is connected with a crime. So they have to have this basic level of evidentiary support to charge someone with a crime. Unfortunately, with our sexual violence cases, a lot of times if there's really not any physical evidence no witnesses, which often happens in sexual violence cases. There are often no witnesses besides the victim and perpetrator. It can be difficult sometimes to find probable cause because it is really we say he said, she said, but of course it could be she said, she said, he said, they said. So that is why in a lot of cases, unfortunately, there is not sufficient probable cause to press charges against a perpetrator. Now, in order to secure a conviction at trial, a prosecutor must prove that the crime happened beyond a reasonable doubt. A lot of times, us lawyers in law school learn about this as a percentage, and that could be something like 95% sure, 98% sure, something along those lines. Basically, jurors are told that they can only find the defendants guilty if they're convinced beyond reasonable doubt. That would mean that the only doubts that could remain are unreasonable. So it is the prosecutor's burden to prove that at trial. It's not actually the perpetrator's burden to prove that the crime didn't happen. It's the prosecutor's responsibility to prove that it did happen. So that's another reason why prosecutors have so much discretion. They need to be confident that they can do that at trial. Prosecutors also decide which crime to charge. It might seem obvious, but there are various degrees, for instance, of rape or sexual offenses, and they each have certain elements that must be satisfied to charge and later convict someone of a specific crime. However, you can also have one crime or one act that actually constitutes a violation of multiple criminal laws. So for one act, you could be charged with 3 different crimes, actually. Some of the more serious crimes are felonies, where some of the, I don't want to say less serious, but legally speaking, that's what they're considered. Those are considered misdemeanors, and those do tend to have shorter statutes of limitations. So that is another thing that may prevent a prosecutor from being able to press charges. If the crime constituted a misdemeanor and too much time has passed, they legally cannot prosecute a perpetrator for that, even if the evidence is overwhelming. Now, a victim may have other legal options, so that's why they should speak with a lawyer. We're going to take harassment as an example, and this is a word that a lot of us use in common parlance. However, in each state, really, they have their own definition with very specific elements, we say. So if you would like in the chat, you can put how you would personally define harassment, and we'll see how well it matches up to Maryland's criminal law that we'll take a look at in the next slide. If you want to just take a quick second. I know it's kind of a word that we feel like we could use, but maybe we couldn't quite explain. And so that's why the legal definition will help us on the next slide. Pattern of behavior that causes distress. Yes, a pattern of behavior is very important. Harassment does tend to be a pattern rather than just one specific act. Looking at frequency, duration, intensity, impact on daily living. Yes, would a reasonable person find this to be threatening or scary? A course of actions against a person that causes them to be alarmed or annoyed. Alarmed or annoyed are good words. And course of action, again, yes, we're looking for a pattern rather than just one specific instance. Unwanted contacts. More than 3 times. It's interesting that you say that because that is kind of how we would think of it in our head, what we would consider harassment. But going to the next slide, thank you for all your input. There is no specific number of times, and you'll find this often in the law, actually, that it is very interpretive. So we have here, this is A, so this is just kind of the overarching intro to the law, but a person may not follow another in or about a public place or maliciously engage in a course of conduct, meaning a pattern, that alarms or seriously annoys another. So here we have that word alarm and annoy, which we had in the chat. Then there are these 3 additional requirements. So the person must have an intent to harass, alarm, or annoy. This can be somewhat difficult to prove sometimes, and because proving intent, of course, you can use circumstantial evidence, like what other explanation could there be, but as you can probably predict, it might be hard in some cases to prove intent. After receiving a reasonable warning or request to stop by the person being harassed or by another person on their behalf. So this is a requirement under our criminal code. Someone has to ask them to stop or warn them to stop. It might seem hard to believe, but if there is no request to stop, unfortunately, legally, we cannot deem it to be harassment. So that's why I do advise my clients often, if they haven't already, that they need to say, please stop contacting me, or blocking someone, maybe like an implicit request to stop, especially if that person can tell that they were blocked. And third, there's a requirement that there's no legal purpose to the continued communication. So as you can imagine, there may be some instances where there is a legal purpose. For example, if this is someone you share a child in common with and they're asking you, how the child's doing, maybe the child's sick, or maybe I think of a legal process server who's trying to serve someone with a summons. Someone could say that that was harassment if they're constantly following someone trying to serve them with papers, but then they would have a legal purpose, so it would not be criminal harassment. An important exception that relates back to our First Amendment's rights is that this does not apply to a peaceful or peaceable activity which is intended to express a political view or provide information to others. So you can probably think of some activists or journalists who kind of follow our congresspeople around or our president around trying to ask questions or express their view or interview him about something that's going on. That would not constitute harassment. And we can see that if it did, there would be some pretty serious consequences for our free speech and our freedom to I'm forgetting the word, to like publish information and be journalists about political views. Prosecutors obviously also have to consider all evidence that the victim provides in a case regarding sexual violence. So that could be photos of injuries, any written statements. So sometimes a victim will write in their diary what happened, or they might write it in a blog, something like that. Any 911 calls, which we know are recorded, and so the prosecutor is able to access those. Police testimony, if the police respond to the crime, then they can tell the prosecutor what they saw in their report. Medical records. Now, this gets a little tricky because medical records are technically privileged, but if the victim would like to turn them over, like in the case of a forensic exam, where kind of the whole point is to turn it over, then the prosecutor will review that. Any physical evidence, so it might be a torn shirt, bedding a lot of times could be used. Lots of clothes, like what someone was wearing might have some DNA evidence or something like that. Electronic evidence I've found to be increasingly helpful. So text messages or voicemails, locations, if you said that you were at this person's house, and then you can prove it because your phone tracked you there, or you parked your car there. But text messages are used a lot in criminal cases, especially if a victim has shared with someone like a friend or family member what happened the day of the crime. And those can be very helpful in future cases. So that's why it is important for victims also to save those texts and any messages they send, really save whatever they can in hopes that the prosecutor may be able to use it either to show probable cause or beyond a reasonable doubt in the future. Can also use mail, of course, in jail calls. So calls that people that are incarcerated make inside of a jail are typically recorded. They're not supposed to be recorded if they're legal calls, but all other calls may be useful. For instance, if someone is confessing to the crime over the phone, which actually may happen more than you think because people don't realize it's recorded. Some confessions, and actually something that wasn't in this list is sometimes police can actually record a confession between a victim and a perpetrator. It's one of the few exceptions to the Maryland wiretap law, and it does happen sometimes. If police think a perpetrator may confess to a crime, they can kind of set up the perpetrator and have the victim call them, and I have seen that in a few of my cases as well, which can obviously be very helpful evidence. Some inadmissible evidence include hearsay or rumors. We'll go a little bit more into that. And you've probably heard the word hearsay a lot, but it's actually a pretty complicated concept, and there are a lot of exceptions. Like I said, the vast majority of the time in a criminal case, there is a plea agreement or plea bargain made between the prosecutor and the perpetrator or the perpetrator's attorney. So a defendant can plead guilty to, for instance, a lesser offense. If they were charged with more than one offense, they could plead guilty to the lesser one, which means they'll likely get a lesser sentence and avoid a trial where they could be convicted of both of these offenses. The benefits, actually, I think of it as a win-win-win situation because the defendant receives a less harsh sentence. The survivor doesn't have to testify in court and be subject to cross-examination, which can be extremely re-traumatizing, as is just having a trial, which can be postponed multiple times. Sometimes it can take years to secure a conviction, and that takes a huge toll on a survivor, of course. And third, it also saves the prosecutor, the court, the judge, and our community valuable resources and time, having to find 12 people to take time out of their day to be a jury for 3 to 5 days, sometimes more. So it really does save everyone some time and emotional toll. Of course, there are disadvantages. So a lot of survivors really envision having their day in court and confronting their perpetrator, telling the jury and the judge what happened to them. Even though that can be very difficult, it can also be very validating in some ways. So the survivor may be hesitant to accept a plea agreement or instead of a trial. The survivor might also not agree with the offer that the prosecutor is giving to the perpetrator. Another thing that can happen is that charges are actually dropped. This could happen if there was enough evidence to charge, but then they realize later there's not enough evidence to actually prove beyond a reasonable doubt that the crime happened. This could be in the form of new evidence that they didn't have before, witnesses that may no longer be available. Unfortunately, sometimes witnesses pass away, sometimes they move to another country, or sometimes they say that they're not going to testify and that if they are put on the stand, they'll lie, which of course is a crime, but we can't really stop them from doing that if that's their choice. Thankfully, as of October 1st, 2023, a prosecutor is legally required to explain to a sexual assault survivor why they are not bringing charges. This is something that we as SALI attorneys help with a lot. If a decision is made about not pressing charges, we can request a meeting, and it is the survivor's right to receive an explanation from the prosecutor for exactly what evidence or lack thereof led to that decision. You might also see charges dropped if charges were brought in district court, and then the perpetrator is going to be indicted in circuit court. So if there's no plea agreement and the case goes to trial, this is basically an outline of the process that happens. So jury selection has a fancy term for it called voir dire. Prosecutors and defense attorneys actually do kind of get to pick their own jury somewhat. Of course, there are a lot of rules with that. Then once the trial actually starts. Both attorneys, the defense attorney and the prosecutor, make opening statements where they basically preview to the jury what they're about to see and what happened. The prosecutor begins with their case, meaning they make their own arguments, they question witnesses first. Of course, the defense can also question their witnesses. And then sometimes a prosecutor may ask that after they presented their case, the judge make a decision right then and there. However, that isn't very typical that the case ends right there. So then the defense or the defendant's attorney presents their case. They will present their own witnesses and make their own arguments. After the defense presents their case, a prosecutor actually has the final word, so they can bring a witness back or bring a new witness if they think it would help their case, kind of to address anything the defense brought up that they hadn't addressed in their first case. After that, closing statements are made. This is the really fiery, passionate part of the case where each attorney, the prosecutor and the defense attorney, make statements to the jury box about what they should decide. And then afterwards, the jury deliberates and they come up with a verdict. It's important to note that the defendant does not actually have to testify under our Fifth Amendment, and a jury cannot hold that against them under the Constitution. So you can see why that would involve a little bit of strategy, whether the defense attorney is going to have the defendant testify or not. Oh, and like I said before, a prosecutor that presents their witness, they will do what is called direct examination, where they ask a lot of open-ended questions. And then the other attorney will have a chance to cross-examine or question that same witness. And they actually have the ability to ask questions in a little bit of a different format. If you ever get the chance to observe a trial, I highly recommend that you look for these differences because there's a lot of little rules that play into strategy a lot, and it's very interesting. After a conviction, there is a sentencing hearing that is usually held separately. Of course, if the defendant isn't convicted, then there is no sentencing and the case simply ends. But after a conviction, either by a plea agreement or a trial, there is a sentencing hearing. That's where the judge decides and delivers the sentence or the punishment. There are guidelines in the state of Maryland which judges consult, as do prosecutors, and these guidelines were created to try to make sure there's some sort of uniform standard throughout the state. This is to address inequities or biases throughout the state, although judges do not have to follow the guidelines exactly. A survivor can make a victim impact statement during the sentencing hearing. That is their right under the law in Maryland as a crime victim. They do not have to if they don't want to, but a lot of survivors typically find this to be a very validating experience, especially if there was no trial. This is their chance to kind of confront their perpetrator in front of everyone. And the judge actually will and must take that statement into account when determining the sentence. So it can be a very powerful tool for a survivor. If the survivor is not comfortable reading the statement themselves, that's completely fine. They can have an advocate or their attorney read it for them, or they can even have the judge read it out loud or silently. There's a lot of different options depending on the judge's discretion, of course. So when a prosecutor first interacts with the survivor, which is their key witness in their criminal case, they reach out themselves or through a victim witness coordinator. I believe every single prosecutor's office or state attorney's office in Maryland has a victim witness unit. And these are kind of like advocates that work in the state attorney's office that facilitate communication, meetings, provide interpretation, things like that. So first, the prosecutors do an initial interview when they decide to charge. Sometimes the prosecutors will just look at the law enforcement interview that the survivor did with police instead of meeting with the survivor themselves. but sometimes the prosecutor would like to meet with the survivor to ask some clarifying questions before making a decision about charging. Although in my experience, that doesn't happen that often. And then if it's requested under the law, the prosecutor's office does have to notify survivors of the case status, so whether charges are pressed, when proceedings are scheduled, things like that. Under the law, a prosecutor also has to inform a survivor about a potential plea bargain. They have to at least tell the survivor about it and allow the survivor to give their input. Now, the prosecutor does not have to do exactly what the survivor wants under the law. However, in my experience, prosecutors do take the survivor's wants and needs very seriously. So as long as the survivor's request is within reason, in my experience, a prosecutor tends to consider their desires a lot when it comes to offering a plea agreement. They also prepare the survivor to testify at trial. They might explain what the process is going to look like. This is especially helpful if the survivor doesn't have a victim's attorney. They might practice a few questions and kind of just explain the overall strategy of the case. It's really important to remember, again, we've said this a couple times, but there is no attorney-client privilege between the prosecutor and the survivor. So that's why it is so important for the survivor to have a victim's attorney if possible. There may be things that come up in terms of things that may incriminate the survivor themselves that they should not share with the prosecutor. They should share with their own attorney, because we want to give them the best chance they have at their case seeing a conviction. And we don't want the victim to be, victim blamed for whatever happened. You might have seen this word Brady come up a couple times in the slides. So Brady is a case in which the courts decided that defense attorneys are allowed to bring up certain things like a U visa application, which is an immigration application. They are allowed to bring up the fact that a survivor has applied for that U visa or visa, and to use that against the survivor to show that the survivor may be lying about what happened. So, for example, a U visa is available to many non-citizens who have become victims of a crime in the United States. So the defense attorney may say to the jury, well, she is lying about this crime in order to get this visa, and they are allowed to provide or show that the victim has actually started that application process or are in the middle of that application process as proof that the victim might be lying. So there are a lot of things that should be discussed with the victim's attorney before any of these decisions are made. Oh, I forgot to take Tara's name off of there. Tara is a great senior staff attorney here at Sally, and this was actually her original presentation, but she's not available today because she is in trial. But I can also provide my email, which Alyssa, I believe, can get to everyone. If anyone has any questions, if you have any questions now, I'm happy to hear them as well. Thank you for citing the actual case, Brady v. Maryland.
All right, everyone. So thank you again, Brandy, for that presentation. If you have any questions for Brandy or Cameron or Summer from the two presentations before this one, please go ahead and put that into the chat. And we can do some Q&A now. And Cameron is still on the call, so she's able to answer some of those questions. Summer did have to hop off for another meeting, so if you have any questions specific to her that can't be answered by Cameron today, I will send those to her and we'll send out a follow-up email with those answers. All right. Brandy, it looks like we have a question in the chat for you. It says, what prompted the 2023 law about telling a survivor why no prosecution?
Yeah, so I'm actually not 100% sure. I would have to look into that. I actually just got licensed in 2024. So I wasn't privy to that when it happened. But I would guess that it involved a lot of advocacy, perhaps from Sally itself, to allow survivors some sort of, dignity and validation by receiving that explanation. I think it probably involved a lot of advocacy on Sally and some other organizations' parts.
Oh, sorry, I was muted. I also wanted to acknowledge that I saw Renee's comment in the chat, and I'm copying and pasting this so we can send it to Brandy for a follow-up email for you.
If I could just add, Alyssa, that in response to Renee, if you wanted to look into the crime victims' rights that Maryland provides by law, that could give you some ideas for what to advocate for in your state as well.
Any other questions? All right. Seeing as no other questions, I'm gonna put the evaluation link into the chat. I do want to note that it's the same evaluation link for all 3 of the presentations today. So again, we greatly appreciate all feedback as we are constantly striving to improve. If you are seeking a certificate of attendance, you must complete the evaluation form in order to gain access to the certificate request form. You can expect to receive a follow-up email later today with a copy of the video recording, all of the PowerPoint presentations for today, as well as the evaluation link. So thank you all again for coming, and we hope to see you tomorrow for the next presentation in the series.